The Honorables, the presiding Chief Judge and Judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Thank you, Mr. Storr. Good morning and welcome to the North Carolina Court of Appeals. We have one case for hearing by this panel this morning, and your panel is myself, Linda McGee, Judge Tyson, and Judge Collins. The first case we will be hearing is Mary Cooper Falls Wing versus Goldman Sachs Trust Company and others, and Ralph L. Falls III versus Goldman Sachs Trust Company and others. Are the parties ready to proceed?
We are, Your Honor.
All right, thank you. We'll hear from the appellant.
Chief Judge and Judges of the North Carolina Court of Appeals, I am Johnny Loper from the Wake County Bar. I'm here with my partner Liz Arias on behalf of the appellant Cooper Falls Wing. I'd also understood that Mr. Penry might be here virtually. I don't know if he's on or not, but if so, he's here on behalf of Ralph Falls III and his children. And we are here today to ask that the court vacate the 20 May 2019 pay order and remand for entry of a new order consistent with this court's opinion. Or alternatively, we ask that this court at least confirm that the pay order neither bars the appellants from pursuing claims for wrongful distributions by the trustee Goldman Sachs, nor does it insulate Goldman Sachs from liability for any distributions it has made or makes from the trust pursuant to the order. Now, let me first note that I am not a trust and estates attorney. Ms. Arias has practiced in that area for 20 years. So we propose to divide the argument in this way, of course, subject to the court's direction. I plan to deal with perhaps a procedural and a jurisdictional issue or issues to the extent the court wishes to hear argument on those, and that would be the standard of review and the substantial right doctrine. Ms. Arias will argue the issues that deal more closely and more intimately with the law of trust. And again, depending on what is said and his attendance here, Mr. Penry may also wish to speak on behalf of Ralph Falls III. So if it pleases the court, I'll turn to standard of review. Now, first, we owe the court an apology. In our main brief, we neglected to provide the court with the appropriate standard of review. Thankfully, that issue is joined in the briefs. Subsequent beneficiaries argued that you should decide this case or review the pay order under an abuse of discretion standard. And we argue that the appropriate standard is de novo. And our position is abuse of discretion might be appropriate when there is an appropriate standard of review if there has been an award of costs. The pay order is not an award of costs. Therefore, it's not entitled to abuse of discretion review. The pay order is not an award of costs because awards of costs can be made only after a final judgment. That's the Whaley case that we cited in our brief. Costs follow the judgment is the quote from there. Now, importantly, the appellees admit that the pay order is not an award of cost or attorney's fees. That's in the Sellers and Cone response brief at page 43. Yet the case they rely on in support of that proposition, the N. Ray Clark case, is explicitly a case that involves an award of attorney's fees after a final judgment, that being in a guardianship matter. The pay order here is not a final judgment. The pay order, respectfully, is a ruling based on the lower court's incorrect construction of a statute. The trial judge interpreted 36C-6-604 to mean that even if the appellants, even if we prevail on our wrongful distribution claim, the trustee is insulated from liability for making wrongful distributions to people who never were beneficiaries under the trust.
May I ask a quick question, Mr. Loper?
Yes, ma'am. Yes, ma'am.
Is there a difference between costs and expenses when we're talking about what this payment is?
There is a distinction, Your Honor, and Ms. Arias can speak to that more closely, but there are costs, attorney's fees are properly part of costs when made in an award at the end of a case. But in the law of trust and estates, as I think Ms. Arias will tell you more fulsomely later, a distribution is exactly that, monies from the trustee to a beneficiary for payment of some personal type expense. An expense is an item spent by the trustee in the administration of the trust. If you pay money to a beneficiary to buy a house, to buy a car, and that's permitted under the trust, that is a distribution to the beneficiary, and I think it's taxable to the beneficiary, although I wouldn't swear to it. But so that's a distribution. It's not an expense to the trust. Expenses to the trust are things like accounting fees, publication fees, and things of that nature. That's the best I can do on that point. I'm sure Ms. Arias will be glad to correct me if I'm wrong on that.
Okay, thank you.
Mr. Lopez, going back to the standard review, good morning.
Yes, sir.
I think we all agree this is an interlocutory order.
Yes, sir.
In terms, and there is no trial court rule 54B certification, correct?
Correct.
So we're solely here on the appellant showing a substantial right that will be lost absent immediate review.
Yes, sir. And that will be, I'm sorry, that'll be my next point, but I'm happy to answer any further questions.
Well, I just wanted to make, while we were on the standard review, before we went on into a merits discussion, I wanted to make sure that that is the level of review that we're at.
Yes, sir. We are saying that a substantial right has been affected, and we are saying that the order is not an award of attorney's fees. Therefore, abuse of discretion doesn't apply. It is it's a statutory interpretation. It is a legal conclusion, and it's clear that legal conclusions are reviewed de novo.
What would be lost by waiting until you bring the whole thing at one time?
Well, that's what we'd like to do. We'd like to bring the whole thing at one time, Your Honor. Unfortunately, this order decides part of our case without there being any proof. This order, as the appellees interpret it, even if we win on undue influence and lack of capacity, the court has already decided in some way that part of our wrongful distribution claim is barred because it is ordering the trustee to make payments. And the appellees say that no matter what happens when this whole case goes to trial, if we win on wrongful distribution, if we win on lack of capacity, they say the trustee is insulated from having made payments to, if we win, people who would never have been beneficiaries under the trust. So that's why we need you to review it now rather than waiting until the end of the case. If we wait till the end of the case, this is what we have. If we win, we have to, even though we win below on our claims, this order would still be out there. We would then, having won in the court below, still have to appeal the pay order because it insulates the trustee from having made payments even to people who were never beneficiaries under the trust. We would then have to appeal that. We would be back here on that appeal. And then if we won here, we would have to go back down for another trial, at least on damages on that part of the wrongful distributions made by the trustee under the pay order.
Your argument is there'd be a risk of an inconsistent order and verdict. Is that kind of where you're going?
Yes, sir. Multiple trials and inconsistent verdicts.
But wouldn't there just be an accounting and a reimbursement?
Well, Your Honor, that goes to the substantial right doctrine, and perhaps that's where I should go next. Can I make one other statement first before I address that? Then we'll be through with standard of review. I would submit that even if the court disagrees with us, I think the law is clear on our point, but even if you disagree, I can't feature a more something that illustrates more an abuse of discretion than a judge entering an order that is an absolute direct conflict with clear trust law and the restatement of the trust. So in our position is that even if you agree with them on the standard of care, we would still prevail on that. I'll turn now to substantial right, Your Honor. It's clear that the court, even though this appeal is interlocutory, and we agree that it is, the court can consider it under the substantial right doctrine because it affects the substantial right, and that right will be lost or prejudiced or inadequately preserved if it's not reviewed before final judgment, as I just mentioned with Judge Tyson. It affects a substantial right because it requires a payment of a substantial sum of money from a fund in which the appellants have an equitable interest, the trust, and will be prejudiced because, as I just said, the order is inconsistent if we win below, the order is inconsistent with our victory on a wrongful distribution claim because it immunizes the trustee from any such liability. Now, I don't think anyone here would disagree with the fact that payment of attorney's fees to this point have involved substantial sums. We understand, at least from the discovery that's happened so far, that number is in the millions of dollars. So under the substantial right doctrine, that satisfies. The appellees, however, say that we can't avail ourselves of that because the payment actually has to be from our pocket. And as we indicated in our brief, that's not so. If you look at the Tanner case that we cite to you, that's a case much like this one, where the issue is who owns the amount of money that's in a constructive trust. And the court there said it was wrong to make a determination without getting facts and proof, not to whether the funds should or should not be in a trust, but to decide ownership of the trust. And essentially, that's what the pay order did here. The pay order preliminarily decided without proof that it's, and in violation of 6-604, that it's okay for the trustee to make distributions to people who may never be proved to be beneficiaries under the trust. Now, they have a related argument that we don't have standing or that our interest is non-existent or too remote or too speculative. It's black letter law in North Carolina, as in the Upchurch case that we cite to you. North Carolina recognizes an equitable interest in trust property. We know that in the trust, in the wills area of the law, that prior beneficiaries under will have standing to file a caveat. A trust is a will substitute. The same thing should hold true here, and it does, as is evidenced by Upchurch.
Let me ask this. Is the basis of your complaint against Goldman Sachs, they are in effect merely a stakeholder of a sum of money that is subject to competing claims, and they should just remain absolutely neutral until those claims are resolved? Is that basically what you're arguing?
Your Honor has foreshadowed much of Ms. Arias's argument. We say that trust law is absolutely clear in North Carolina, Your Honor, that a trustee is supposed to be a neutral, just as you noted. The trustee here has picked a side and is funding that side of the litigation in derogation of the rights of original beneficiaries who have an equitable interest in that trust under the law.
It'd be almost as a will contest where the executor would await complete competing claims over heirs or beneficiaries before distribution. Is that a good analogy?
That apparently Ms. Arias thinks so, Your Honor. She is nodding her head, and I will follow her lead. Yes, sir, that's exactly correct.
Thank you.
Yes, sir. Just to follow on what you were talking about inconsistent trials a moment ago, Your Honor, the Carcano case says we have the right, the Carcano case we cite, we have the right to have all of our claims tried at the same time by the same judge, by the same jury. And that will not happen if the court doesn't act here, because there will be a claim, our wrongful distribution claim for distributions made pursuant to the order, that we will have to come back to even if we win in the court below. Now, while this appeal is certainly a complex appeal, I think the situation I just described, where we win, we have to appeal, go up, come back down, and perhaps go back up again, I respectfully submit would be a bigger problem for the court. Now, since this may be my final word for the day, unless the court has other questions, what my request would be is fix this problem today, correct the trial judge's error and his conclusion of law that it's okay, despite what 6-604 says, for a trustee to pick sides and pay the litigation fees for one side and a trust dispute over the other, and reverse the pay order.
Mr. Loper, I'd like to go back to my question. Would there not just be an accounting and a reimbursement at the end of the process?
No, ma'am. I think if you view the cases that we have cited in our brief under the substantial right doctrine, it's clear that as long as there is a payment of a substantial amount of money, that there are some cases that say there's just a truing up at the end, But I think once you get into the neighborhood where you're talking about millions of dollars, I'm comfortable and confident that under the cases we cited to you, this satisfies that prong of the substantial rights test. It's not just an accounting. If millions of dollars go out of a trust.
All right.
Thank you, ma'am.
I have one last question, Mr. Lopez, before you leave.
Yes, sir.
And I may have not heard this. Did the appellant reserve rebuttal time this morning?
Yes, sir. 5 minutes.
Okay, thank you.
Yes, sir.
Good morning, Your Honors. My name is Liz Arias, and I'm going to address the trust and estates issue. Judge McGee, I did want to answer your question about whether or not a reimbursement in accounting at the end of the case would be an option. And it would be, but for the fact that the trustee has taken the position that the pay order insulates it from liability for 100% of the distributions that it is making to the subsequent beneficiaries to pay their legal fees. And that, in a nutshell, is why a substantial right has been affected. Because even if we ultimately prevail on our claims and the assets, and we are determined to be the beneficiaries of the trust, we cannot, pursuant to the trustee's position, recover from them the millions of dollars that they distributed to the subsequent beneficiaries in an unsuccessful attempt to prevail. Does that answer your question, Your Honor?
Certainly helps. Thank you.
Essentially,
Is it
why
also-
this issue?
I have a question. Is it also your contention that this order bars going back against those who received the funds? Isn't that part of your argument as well?
Your Honor, that question is, I'm not sure if the pay order would do that or not. Certainly under 36C-604, the statute itself says that if we prevail in our claims, that we have a right to go against the beneficiaries who were determined not to be beneficiaries to recover funds, but the pay order is unclear on that point.
So when you say unclear, are you arguing that because it's unclear that it potentially bars you from doing that, or are you saying that it doesn't bar you from doing that?
It potentially bars us from doing that, and I would venture to guess the subsequent beneficiaries counsel would argue that it does.
Okay.
The issue
I have
here
a
on
question.
it.
Excuse me, I'm sorry. I have a question before you go further. Are you arguing that you would be not able to be reimbursed from Goldman Sachs or from the beneficiaries?
Goldman Sachs, in its brief, takes the position we are barred from recovering from it. It is unclear as to whether or not the subsequent beneficiaries maintain that we also could not recover from them.
So if you cannot recover from Goldman Sachs, that in your contention standing alone would be enough to assert a substantial right?
Correct, Your Honor. In addition to the fact that even if we had the right to go against the beneficiaries, if they're spending this money on their legal fees, so unless they have another pot of assets from which we could recover, we would essentially be left with a judgment that's uncollectible.
Judge Tyson, you're muted, sir. You need to ask your question again, Judge Tyson. I'm sorry, sir, you're muted. You need to turn on your mic. I'm sorry, sir, we're not hearing you.
Can you hear me? Okay, I'm sorry. Why would you not be able to bring an action directly against Goldman Sachs if you prevail?
Your Honor, we have asserted that claim, and it's in our complaint. We have asserted a claim for wrongful distributions. But your question gets to the heart of the matter. Goldman Sachs and the subsequent beneficiaries argue that our claim for wrongful distributions does not apply to their decision to make distributions from the trust in payment of the subsequent beneficiaries' legal fees. They assert that those payments are outside the reach of our claim. We disagree, and that's the fundamental issue that's an issue of first impression for this court. Namely, is what can a trustee do in a lawsuit where competing beneficiaries assert a right to the assets of the trust?
Sorry, Judge Tyson.
I don't understand why you could not bring that action separately.
Your Honor, we have brought that act. Well, if we have asserted that exact claim as one of our claims for relief in our amended complaint, and the trustee is taking the position that a claim for wrongful distributions, apparently whether brought in the current complaint or separately, doesn't apply to what they're doing. And that's the key issue here, is that, I mean, there are other courts in the country that have considered this issue. We do not in North Carolina have an opinion specifically on this issue, which is, what are the duties of a trustee when two sets of opposing parties claim to be the actual beneficiaries of a trust? We do have, under our trust code, 36C-604. That statute clearly states that when there's a trust contest, which this is, because we are contesting the validity of the terms of the trust as expressed in the Fifth Amendment, and we are asserting that the terms of the trust as set forth in the 2011 revocable trust are the correct and valid last terms, that in that case where you have a trust contest, 604 says, if the trustee makes distributions to a beneficiary who is ultimately held not to be a beneficiary, then the trustee is liable for those distributions, period. And that actually narrows what the law used to be. Under common law, a trustee is strictly liable for any distribution made, even if it believes in good faith that it's making it to a proper beneficiary. 604 says if you...
So in this case, does the trustee argue that because it would be pursuant to a valid court order that they would then be insulated? Is that the thrust of that argument?
Yes, that's right, Your Honor. And in addition to that, they argue that the basis, the reason why the order was properly entered is because this is not a payment that falls within the purview of 604. Instead, they argue that they have a duty to defend the trust, and in furtherance of that duty, they can just pay the subsequent beneficiaries' legal fees. They need both of those statements to be true in order to bring these payments outside of the reach of 604. And Judge Tyson already asked the question that I think is the fundamental question with respect to the duty to defend the trust. We do not disagree that in certain instances a trustee has a duty to defend. An example would be the Chinnis case, which is cited in our briefs. In that case, real property was foreclosed upon, leaving a balance owed. The entity that was owed the money tried to come against a trust and get the trustee to pay the balance due. That would have taken money out of the trust and paid it to a third party to the detriment of the beneficiary. The trustee has a duty there to defend against that. We say that in a trust contest between competing beneficiaries who each claim to be rightful beneficiaries, there's no duty to defend there. Nobody's taking away from the pot of assets. It is what it is, and at the end of the day, one set of beneficiaries is going to prevail and get that pot of assets. Judge Tyson analogized that to a will caveat, where there's always a freeze order entered, and the beneficiaries fight it out, and at the end of the case, someone is determined to be the beneficiary and gets the money. There's no duty to defend in that type of litigation, but the trustees say there is. One of the reasons they say that is they say, oh, well, the Fifth Amendment is its own trust, and the original beneficiaries are attacking that trust, and they're saying that the 2011 trust is the valid trust. That is misleading because there is only one trust. It has simply had its terms amended over time. Much like if you had an LLC with an operating agreement. Every time you amend the terms of the operating agreement, you do not have a brand new LLC. You just have new terms. The trust was created in 2011. There's only one trust. The various amendments put in and took out beneficiaries, and there is a fight over which set of terms is the correct and valid terms. In that instance, the trustee has a duty of neutrality. The trustee needs to sit back and let the beneficiaries advocate their own positions. What the trustee cannot do is prefer one set of beneficiaries and pay their legal expenses and call that a, quote, trust expense, and then argue that they're insulated from liability under 604. This is not a trust expense. If the trustee hires an accountant and pays the accountant, that is a trust expense. If the trustee gives the beneficiary money to pay the beneficiary's accountant, that is a beneficiary expense for which the trustee has made a distribution to the beneficiary so that the beneficiary can pay its own expense. Essentially, what you have here is subsequent beneficiaries who want the costs of the attorney's fees that it takes to advocate their own position paid for them by the trust. The trustee has breached that duty of neutrality and impartiality, is giving them the money, and then the subsequent beneficiaries and the trustee are arguing, and original beneficiaries, if you win, you can't have the money back. No matter how many millions of dollars we've given to them for legal fees, there's no liability to us for having made that decision. So in essence, this is a dispute about whether or not the payments the trustee is making fall under 604, or whether the trustee is correct that even in this type of litigation, it has a duty to defend the trust and can prefer one set of beneficiaries over another and fund the costs of their defense. I'm almost out of time because we're reserving 5 minutes for rebuttal. Does anyone have a question at this point?
Thank you, Ms. Arias.
Thank you.
We'll hear from the appellee.
Thank you, Judge McGee. Good morning. My name is Alan Duncan of the Guilford County Bar, and along with my partner, Allison Mullins, we represent the defendant appellee, Diane Sellers, Mr. Falls Jr.'s widow. We also appear with my colleague, Leslie Packer of the Wake County Bar, who represents defendants appellees Louise Cohn, Mr. Falls Jr.'s daughter, and her family. The joint brief was filed by these appellees for efficiency purposes, and I've been asked to make the oral argument on behalf of the parties. Our intention is to reserve 5 minutes of our time for counsel for Trustee Goldman Sachs. I'd like to give a very brief statement of the case and some relevant points, and I will do that quickly. Mr. Falls amended the terms of his revocable trust several times, the last of which was embodied by the Fifth Amendment. The First Amendment and every amendment thereafter, Cooper Wing, his daughter, was removed. Mr. Falls documented carefully the reasons for that removal, which has to do with he being very upset with her for going through his personal papers and sharing that information with his former wife and never apologizing to him for it. The Third Amendment and the subsequent 2 amendments excluded Mr. Falls' son, Ralph Falls III, and his children. Mr. Falls wrote about his displeasure directly to Mr. Falls III about the way he spoke to Mr. Falls' medical providers. In addition, he was given, despite having been given very substantial assets by his father, when Mr. Falls loaned him money in the summer of 2013, he refused to acknowledge that it was a loan and did not repay it. Ultimately, Mr. Falls had to sue his son in order to recover that money, which suit carried on after the time of Mr. Falls' death. While Mr. Falls was in the hospital in late 2013, Mr. Falls III took out a durable power of attorney and sought to take over Mr. Falls' financial affairs. This caused Mr. Falls to have to undertake a competency exam in January of 2014, in which it was declared that he was competent and by an independent physician, Dr. Fosdar. In the competency report, Mr. Fosdar said he was capable of making rational and informed decisions about his personal, family, and financial matters. Mr. Falls then revoked that durable power of attorney the following day. In addition, affidavits from Mr. Falls' treating physicians, Dr. Weissler and Dr. Anderton, who evaluated Mr. Falls on or about the date of execution of the Fifth Amendment in early December of 2014, both attest to his competency and confirm that his decisions were of his own free will. Mr. Falls died in May of 2015. The appellees are defending Mr. Falls' final testamentary, easy for me to say, wishes as expressed in the terms of the revocable trust that are contained in the Fifth Amendment.
I'm so sorry. I just want to jump in and ask why, when we talk about attorney's fees, usually we talk about those being awarded after the case is over, and especially when they are awarded to the party who prevails. Why in this case are there interlocutory attorney's fees, and why is that okay?
I actually think that goes to the merits even after we have to discuss the interlocutory question, but the short answer as we go to the merits will be our statutory scheme presumes that the beneficiary at the time of the death of the decedent is the beneficiary intended by the decedent, and the presumption is under our law that the decedent's intended wishes are for the beneficiaries at that time to be the ones who receive the benefits that are set out. And in that regard, the statutory scheme also provides for the ability of the trustee to assign as expenses such professional services that are necessary in order to properly defend the trust or assist in the administration of the trust, which Goldman Sachs has done here to the counsel for the two beneficiaries in order that it not be accused of not being neutral by taking the positions that are adverse, if you will, to the beneficiaries who were in the original trust that had been written out for some time by the amendments. I should say here also, the amendments are not the only issues that in terms of beneficiaries that were changed. There also were changes about who the trustee was multiple times. There were also changes with respect to a marital trust being placed into the Fifth Amendment. So the changes made by Mr. Falls were multiple. It was not just the beneficiaries. I believe Judge Tyson may have been trying to ask a question, but I cannot hear it.
Judge Tyson, we can't hear you again. Thank you.
Yes. My question is, why is this any different than a dispute over a will where you have various purported claimants and beneficiaries and heirs that are claiming against each other? They're not claiming against the estate. They're making competing claims over their status. How's that any different than what we have here?
I think what we have here is there is a presumption with respect to who is named expressly in the document that they would be the intended beneficiaries of the trust.
How's that any different than a will?
Well, our account, both Wing and Falls III are not in the Fifth Amendment. They're not contemplated to be part of the trust. And in fact, they are clearly written out and there is documentation as to why.
Why would that be different than a codicil to the will? For example, a codicil to the will amends the will. It doesn't necessarily revoke the will. This amendment amended the trust. It did not create a new trust, did it?
No, it's the Fifth Amendment is the embodiment of the time of the decedent's death trust, would be an accurate way to say it.
Does the amendment not restate all terms of the trust not expressly amended?
It does.
So the original trust is still the trust as amended, correct?
Yes, but the litigation is over the terms of the trust relating to who the beneficiary is.
And again, we have competing claims, the same as we would in a will contest.
We have competing claims, but the most recent version of the Fifth Amendment, in fact, is the one that names the beneficiaries that are the defendant appellees in this case. The defendant appellees have been assigned and delegated. I think it's important to say Goldman Sachs didn't just pick a side here. The actual beneficiaries are presumed to be correct under our statutory scheme. And Goldman Sachs is not making distributions, but rather has selected them as a party with the most efficient way to defend the claims that have been asserted against the trust in its final form to the Fifth Amendment. That's an efficient approach and allows Goldman Sachs to also maintain its neutrality by having the expenses allocated in that way.
Wait, can I just clarify that? So Goldman Sachs has, under this presumption, Goldman Sachs has chosen these beneficiaries as the ones who will get their attorney's fees paid as the most efficient way to decide the case?
These beneficiaries are the ones that are named in the Fifth Amendment, effective at the time of death. They are the presumed beneficiaries to this trust. And Goldman Sachs selected the presumed beneficiaries to defend the trust in its present form, which was as embodied by all the terms, including the terms in the Fifth Amendment? Yes, is how I would answer that with that caveat. Going forward and looking at the grounds, the interlocutory appeal issue.
Sorry, Mr. Duncan, may I ask one more question too? You were
Sure.
talking about our statutory scheme for this process and the presumption. Is there a particular statute that we ought to be considering?
Your Honor, Chief Judge McGee, I did not hear the last part of that question.
I basically said, is there a particular statutory statute that we should be considering in this matter?
Well, I will take you through the scheme and answer that question if I could.
All right.
The last will of the decedent, when probated, is presumed valid and operative until a court determines it is not. That's set out in North Carolina General Statutes 36C-1-112. The rules of construction that apply to wills apply to the disposition of trust property. This is well accepted concept in North Carolina law, is codified in North Carolina General Statutes 28A, 2A through 12. Under the trust code, wings and falls the third's attacks on the trust amendments are external attacks by non-beneficiaries on the validity of the operable terms of the trust, as set out in the Fifth Amendment. The fact that the trusts are external attacks is supported by the trust code 36C-6-604A1, which says that a judicial proceeding contesting the validity of the trust and the comments to that statute, which define an action to invalidate all or part of the terms of the trust. This is an attack on the validity of the trust. Wing and Falls III are undertaking this attack despite the fact that the terms, as Judge Tyson pointed out, were restated throughout. 36CA-801 says a trustee shall administer the trust in good faith in accordance with its terms and purposes and the interests of its beneficiaries. 36C-8-811 says a trustee shall take reasonable steps to enforce claims of the trust and to defend claims against the trust. 36C-8-81624 says the trustee has the power to prosecute or defend an action, claim, or judicial proceeding in any jurisdiction to protect trust property and the trustee in the performance of the trustee's duties. The trustee has a right to be reimbursed for costs defending the trust, as set out in NCGS section 32-58, which says a trustee shall be entitled to reimbursement out of the assets of the trust for expenses properly incurred or advanced in the administration of the trust, and shall be empowered to pay the expenses from the assets of the trust. NCGS section 36C-7-709 similarly says a trustee is entitled to be reimbursed out of the trust property for expenses properly incurred in the administration of the trust, which would include defending the trust.
Can you answer me this? Why is this characterized? You said defending the trust. The assets or race of the trust is subject to competing claims. And I don't understand how the trust is being attacked when the ownership of the race or the assets is the only issue that I see, unless it's a different issue. And we've already established that the trust is the original trust as amended. And it seems to me that the challenge is to the validity of an amendment. So I'm having a hard time understanding how the race or the assets of the trust is any more than just competing claims to that itself, where the trustee would normally, once that's determined, be bound to disperse according to that determination.
Your Honor, I think that the answer to that question is that the trustee is defending against the Fifth Amendment, which embodies all the terms of the trust. Now, for example, it's not just beneficiaries. The defendant Wing has contested and said that there should be an annulment of the marriage of Diane Sellers. And in fact, in the Fifth Amendment, there is a marital deduction that's set out That's different than just beneficiaries, and that has a substantial effect on the value of the trust in terms of how that may be dealt with ultimately by the tax authorities. So it's not as straightforward as just who the beneficiaries are. There are other terms in the trust that are at issue. And in this case, Frank.
Are they not all competing claims against the asset? Everything is a competing claim against the asset of the trust. Is there anything itself that's different from that?
I'm sorry, Mr. Duncan, we have lost you, sir. Unless, let me see what we can do to remedy that situation.
Perhaps the clock should be stopped.
Jean, thank you, sir. If you could be in touch with Fred, I'm attempting to do so myself now.
Your Honors, Mr.
Yes.
Wood is attempting to phone Mr. Duncan.
All right. Thank you, Mr. Sorrell. This is why we build in extra time if necessary. And we will have plenty of time to be able to complete our argument.
And Your Honors, just to let you know, approximately 22 seconds went off the clock between the time Mr. Duncan dropped off and the time it was stopped.
Thank you, Mr. Sorrell. Mr. Finley, we did note that you are with us at this point in time, too, sir.
I have a note from Ms. Packer that says they are working on reconnecting.
All right, thank you. Welcome back, sir.
Glad to be back.
The clock was stopped at the recommendation of Judge Collins, and we will add 22 seconds at the end of your time to make certain that you have the full time, sir.
Thank you so much. So I believe I was trying to answer a question from Judge Tyson, if I could complete that answer, starting there, I'd point out that the purpose of a trust is to avoid probate, whereas a will ability is to be determined after probate. So there is a distinction because the instruments are trying to do two different things. And so I think that is a distinction with the meaning in purposes of this case, in trying to make a resolution of the case. And I do think it's important to note that the trustee has the ability to authorize the payment of expenses, which can include professional fees, in order to defend against the trust, which is the professional judgment made by the trustee here.
Well, I guess the next question, this was a revocable trust that became irrevocable upon Mr. Fall's death, is that correct?
Those are revocable trust. I don't know that it became irrevocable upon his death. I think essentially that's the pragmatics of it, I think, yes. Okay. Let me circle back to what I haven't talked about at all first, if I could. Interlocutory appeal, as we moved into the merits fairly quickly there. The interlocutory appeal issue is important here because the defense cost order did not dispose of the case and is in fact an interlocutory order. And I don't think that the appellants have demonstrated that the defense cost order deprives them of a substantial right. They do not have to pay anything under the defense cost order. And the traditional finding is that there would be such a finding of there would be some payment. With the defense cost order, and I think this is a particularly important point, affects Wings or Falls III's financial interest is hypothetical. The number of times the word if was said in that argument, if this happened, or if that happened, or if this happened, was multiple times. And the case law suggests that a hypothetical does not create a substantial right under the appellate case law. In fact, we would suggest that the hypotheticals that were suggested are things we do not believe will occur, number one, and number two, some of which are pretty clearly, just from the recitation of the record, which is one of the reasons I did it, pretty clearly going to be subject to substantial question. There's also no substantial right based on a risk of inconsistent verdicts. We do not believe that the appellants have shown a risk of inconsistent verdicts. The issues to be determined on remand from any future appeal of the defense cost order would relate to payments made by the trustee pursuant to that order and how those would be treated by the trial court. The issues would not relate to Mr. Fall's alleged capacity or any undue influence concerns on the dates of the 6 trust amendments, because the trial court or jury would have already determined those issues. In that instance, the ifs again become significant, that is the hypotheticals, because none of us know exactly how that will play out, and none of us know exactly how the trial court judge will deal with those issues as it goes forward. And so we're speculating about what would happen with respect to trial court activity and further appeals, or what the subject of those appeals would be. And that again is a subject that's not appropriate for allowing an interlocutory appeal. Finally, with respect to the inconsistent verdicts argument, we would note that it is true that Wing has a wrongful distribution claim, but Falls III does not. So with respect to that claim, which is part of the basis of the assertions that are made here, the order would still remain in effect with respect to one of the parties. And that part of the order would affect a substantial amount of the discovery that would be necessary in the case. I'd like to briefly discuss standard of review as well. We believe the standard of review is abuse of discretion. There is a Rule 2.1 judge appointed to oversee 5 lawsuits brought by plaintiffs, 2 of which are before you today. The trial court judge has become immersed in the complexities of these legal proceedings. The trial court determined that the trustee, a well-known and experienced financial institution, should be able to exercise its professional judgment in pursuing the most effective way, the most efficient way, provide for the defense of the trust as part of the administration of the trust. The trial court's defense cost order reflects that determination, which should not be disturbed absent a showing of abuse of the exercise of the trial court's discretion. The Clark case, which was recited in the argument and is briefs of both parties, I believe, suggested attorney's fees, even when authorized by statute, is within the trial court's discretion and will only be reviewed for an abuse of that discretion. Now, it is true that the Clark case involved a finding of attorney's fees that was at the end of the case. I think that's a point being made. To the extent that there's case law, neither party can point you to case law talking about attorney's fees within the case. We can show you cases about expenses by the trustee that are during the time of the case, which is why there was oversight sought from the court as to the appropriate process to proceed in terms of what makes the best sense. And so as a result of that, the trial court authorized such payments, and you will note in the order also reserved any claims that have been asserted against the trustee as not being affected by that order. We believe the proper standard is de novo. With respect to the cases that were, is abuse of discretion. With respect to the de novo argument, the cases cited by appellants in their brief involved injunctive relief, which is not an issue here, declaratory judgment case, which is not an issue, and trustee misdealing, which again is not an issue in this case. So we believe the cases that are most analogous, in fact, relate to the awarding of attorney's fees, which traditionally go into the abuse of discretion area for the court to make its determination with respect to the standard of review. The issue in this case really is whether the trustee satisfies its duty to defend a revocable trust as embodied in the terms of the Fifth Amendment to the trust, using its business judgment through the beneficiaries, Sellers, and Cohn family. In an effort to avoid confronting that issue, the non-beneficiaries Wing and Falls III attacked the validity of the terms of the trust that are embodied in the Fifth Amendment, which is not before the court in a fully developed record at this time, which is exactly why interlocutory appeals, which end up being fragmentary, repetitive, and brought too often in a premature state, would not be appropriate basis to decide this appeal upon. The last will of the decedent when probate is presumed to be valid and operative. And so until the court determines it's not, the trustee should be able to exercise the appropriate judgment while also honoring the request of neutrality that's been made on behalf of the defendants, the plaintiffs in this case, but still be able to defend the terms of the trust. The trustee.
How do you respond? How do you respond to the appellant's assertion that the assets of the trust, the ownership to which is being disputed, is being dissipated, and in the event they're adjudged to be the true owner, that the assets of what they own have been dissipated?
But Your Honor, I would first note that they have already argued to the court that they would have a basis to recover, and as they read the law, they would have a right to pursue a claim to try to recover those assets. So they, in their answer, suggested there would be some way to seek recovery of those assets. Again, we're into the area of hypotheticals, and so we do not know exactly what the issues would be at that time. And so taking it up now with those hypotheticals out there and with plaintiffs themselves suggesting they may have a remedy would not appear to be appropriate with respect to this particular order. And with respect to this particular order.
And also, they also contend, though, that the pay order is protecting the trustee and that they could not make a claim against the trustee.
Well, they contended that, but at the same time, they've indicated they would have an ability that they disagree under the law, and they would have an ability to bring a claim against the trustee. The trustee obviously does not agree with that, but they contended both. They did not claim they couldn't. They said they believed it could present an obstacle, that they believed they had a right to pursue a claim about it. And so,
does the pay order, in fact, protect the trustee?
I think the pay order speaks for itself, and what it says is that the issues that would remain with respect to the trustee, any issues that have been raised with the trustee, would be unaffected by the order. And that's not a quote. I don't have the order language in front of me, but that's the effect, Mr. Armbruster, I'm sure, would be glad to address that directly on behalf of the trustee. But I will say the trustee under 36C-8-807A may clearly can delegate its duties and powers to a prudent representative with respect to these issues. I think it's important to spend a moment on footnote 5 of the appellant's reply brief. Wing and Falls III contend that allowing payments to defend the terms of the trust would, quote, encourage undue influence, and that alleged wrongdoers would have access to trust assets simply to outlast the true beneficiaries in any subsequent challenge. They then go on to say that would be very bad law. This gets to the heart of the matter in some respects if we're going to move to the merits. Now, we believe that it's interlocutory appeal and it's an abuse of discretion standard. But this assertion, which is the heart of their case, is contrary to the position that it would be contrary to that position. It would be exceedingly bad law and a totally inappropriate policy. The beneficiaries of the final and presumptively valid testamentary document, as established by North Carolina law, not to be in a position to defend that document. This would turn the long-established public policy in North Carolina upside down. The presumption would then be that for all North Carolina trusts, the beneficiaries of a presumptively valid testamentary document would not be able to defend that document to the detriment of the decedent's intent unless they happen to have such resources available to do so on their own. We have not traditionally asked beneficiaries to do that in North Carolina. This was the public policy in North Carolina would not only conflict with existing statutory requirements, but would also undermine the effort to uphold the decedent's intent, which is ultimately the goal here of all trust and estates law.
Aren't the appellants contending that they are the true beneficiaries? Isn't that the entire gravamen of the complaint?
The appellants are contending that, but in the last document, the North Carolina law, I understand that contention. North Carolina law has always been the presumed intent of the decedent is to get whoever is in the last surviving document as the beneficiary, and that would be the intent. You would now be requiring to go in the other direction. I must stop here to leave time for Mr. Armbruster, and so we'll do that. And thank you for the panel's questions, and thank you for your time today.
Thank you.
Good morning to the panel. Just briefly, since I have limited time, Mitch Armbruster. I represent Goldman Sachs, who, as you know, is a large institutional trustee. A trustee in North Carolina and under the Uniform Trust Code has a duty to defend claims against a trust. For a period of time, once this case moved from a long period in federal court to state court, the trustee was not paying for any defense of the trust, asked us to approach the court for guidance. That is what the trust code allows. How does the trustee meet its duty to defend the trust, especially in light of all these incendiary claims that are made by appellants? We wanted the court's guidance, and we're allowed to do that. And the whole theory that the trustee is liable is an admission by appellants that this is an attack on the validity of the trust. This idea that the trustee could be liable for these payments as distributions is based on 36C-6604, which only permits liability if you have a claim against the validity of the trust. That is what this claim is. Now,
Let me ask you this. Goldman made the decision, you just stated initially, not to fund the litigation expenses of any of the purported beneficiaries. Is that correct?
well, no, we went to the court for guidance. We had made some payments. That's why there's some tailing wrongful distribution claim that may still exist in the complaint. But no, once the state court case was filed, we went to the court for guidance because we believed that we had that duty to defend the claims against the Judge Tyson. So that's why we took that up.
Let me ask you, generally, if they're competing claims to ownership of the trust assets, in the normal case, wouldn't the trustee just allow the validity of those claims to be established before they would make disbursements to one purported group of beneficiaries as opposed to the other?
Well, that's not the case here. Judge Tyson, really gets to the heart of the problem with their case. If this trust said, my second son gets 30% of the claim, and there was a dispute over who the second son was, the trustee wouldn't do anything with that. The two sons could fight over who was the second son. Here we have an attack on the fifth trust and who are the beneficiaries of the Fifth Amendment, which is the document that names Goldman Sachs. We're not even the trustee of the older trustees. We would not serve as the trustee of these earlier trusts because it doesn't have terms we require. What they're claiming.
I want to clarify before you go forward. Clarify this now. Are you assuming? Are you asserting that the Fifth Amendment itself is a separate standalone trust and not merely an amendment and restatement of the original trust?
It is a restatement, and one thing that's not been talked about is that this trust wasn't even funded until after the Fourth or Fifth Amendment was entered into. So if you go back to the prior documents, there was no res in the trust. He didn't actually put money into the trust until we got to the current distributions. He never put, there'd be $0 if they get back to the First or Second Amendment, but that's, there's a lot of complexities in this case.
Am I also correct that it was a revocable trust that became irrevocable only upon Mr. Fall's death?
He could revoke it until he died, and obviously he can't by circumstances of his death. The last point I want to make.
So how is this different than a will contest where you have competing claims over the validity of codicils to wills from various heirs and beneficiaries? How is it any different than that?
Well, so here the trustee has a duty to defend the trust, and what they are claiming
just as
is that
the executor would have the duty to defend the estate, but they're competing claims to the asset of the state, and here they're competing claims to the assets of the trust. You're presuming the validity of the Fifth Amendment where that is being contested.
Right, and I have a duty, the trustee has a duty to defend the validity of the trust as we are appointed as trustee.
Not when it is in question.
Yes, when it's in question, because otherwise the appellant's theory would mean that as long as someone else claims that, that the trust was invalid and that an earlier document applies, the trustee would never be defending trusts. Because that's always what these cases are, that someone says that this document is invalid and some earlier document that the decedent executed is valid. So
let me ask another way. Are they disputing the validity of the trust or the potential beneficiaries of that trust?
They're disputing the validity of the trust, Judge Tyson, because the theory upon which the trustee can be liable for wrongful distributions, even though these are expenses, is in 604, which the trustee can only be liable for wrongful distributions if there's a claim contesting the validity of the trust. If this is not a claim contesting the validity of the trust, there's no liability for wrongful distributions. You have to challenge the validity of the trust.
Do you agree the trustee has a duty to be neutral as between competing claims?
So we have the trustee, of course, is going, if the outcome of this litigation determines that an earlier version of the trust is in force and Goldman Sachs is still the trustee under that earlier document, they're going to follow the terms of that document. They're certainly neutral as to that, but they're not neutral as to their duty to defend claims against the trust. And this is a claim against the validity of the trust. If it wasn't, the trustee would never have to defend trust claims, because that's what these claims always are, is that we have here, is someone saying that document isn't valid, some earlier document is valid. So that's why we went, because this is a very contentious case, Your Honor. So that's why we went to the court for guidance to get that all out of the air, what all these parties were saying, because we have that duty to defend the trust, and we're an institutional trustee. We're not picking sides. We're an institutional trustee.
Let me ask you this, or is it your position that that Goldman Sachs your client be immunized from any reimbursement in the event the appellants would prevail on their claims?
For the period of time of the court's instructions, we are being compelled to make these payments. The trustee has been ordered to make these payments. There's a short period of time before the judge's order that there was some small advancements given to some of the beneficiaries, and those were shut down. they have a wrongful distribution claim theoretically as to that. That's a small portion. But as we're compelled to pay these fees, we do believe that we're required to make that payment under the court's direction.
And what would happen if ultimately the appellant wins on its issues that they are the rightful beneficiaries?
Then the remaining sum of, so the fees, the money that's been expended defending the trust, those are valid trust expenses. The remaining sum, the remaining res of the trust would be distributed according to the terms of, if a different document is determined to be valid, and if Goldman Sachs is still the trustee under that other document. If they, under their claims, Goldman Sachs is not going to be distributing any money. They won't be the trustee. And I think that there'll be a trust with $0 in it back in those times because there was no res back there. But whatever's left, Your Honor, would be distributed to whoever is determined by the court if it's under a different document.
Would be,
Judge, I believe.
sorry.
Go ahead. Thank you. Thank you, Ms. Dunbruster. We'll hear from the appellant.
Thank you for the extra time.
Certainly. Hear from the appellant.
Thank you, Your Honor. Can you hear me?
Yes, we can. Thank you.
Judge Tyson, this is exactly like a will caveat. And North Carolina has a long established body of case law that in a will caveat, the determination of who is entitled to reimbursement for attorney fees occurs at the end of the case after an adjudication on the merits. The Uniform Trust Code specifically states that a revocable trust is a will substitute, and 36C-1-112 says you apply the same presumptions that you apply to wills, you apply those to the trust code. This should be treated no differently. First of all, let me also say the trustee never went to the court for guidance. The only thing that was filed was a motion by the subsequent beneficiaries to have their defense costs paid. The trustee has never petitioned for guidance. The trustee has unilaterally picked one set of beneficiaries and then makes the argument that we are attacking the validity of the trust, which is untrue. The official comment to 6-604 says, a contest is an action to invalidate all or part of the terms of the trust. That is what we are doing. There is a 2011 document under which we are the beneficiaries and none of the subsequent beneficiaries are beneficiaries. Over the course of the amendments, our interest went down and their interest went up, such that by the Fifth Amendment, we no longer have any interest and they get all of the trust assets. This is exactly the same thing that happens in a will caveat, where the will gets changed over time. Now, Mr. Duncan states that, and this is in their brief, that a party's final revocable trust is presumed to be valid and is the only operable trust document unless and until it is declared invalid, and cites the matter of estate of Phillips case, which is a North Carolina Court of Appeals case that Judge Tyson, I believe, you authored. And in that case, it in no way stands for the proposition that the Fifth Amendment is presumptively valid and that the trustee may treat a contest as if it is a claim against the trust. Instead, the estate of Phillips deals with a will caveat and the presumption of capacity, and indicates that generally the decedent is presumed to have capacity, and the burden of proof is on the caveator to prove that he did not. And of course, we all know that in will caveats, presumptions can change depending on if the beneficiary was in a fiduciary relationship with the testator. And indeed, all the presumption is an issue, an evidentiary issue at trial as to where the burden of proof lies. And we cite to North Carolina Rule of Evidence 301 in our brief, which explains how those presumptions are treated at trial. Regardless of where the burden of proof lies, all we have here are competing claims as to who are the right beneficiaries of the trust. We assert that the Fifth Amendment was executed at a time when the decedent lacked capacity and was the victim of undue influence. They disagree. There's been no trial on the merits of that case. And despite that fact, the trustee has decided to make distributions to fund, apparently to the tune of all of the trust assets, if that's what it takes, the litigation costs of one set of beneficiaries, leaving us with no remedy at the end of the day if we ultimately prevail on the merits of our claims. The trustee takes the position we cannot recover the money that was given to them to pay their defense costs. This is not a defense of a trust case. There simply is no duty to defend where you have competing sets of beneficiaries. And I would leave this court with the language from the California case Whittlesey versus IAO, which is cited in our brief, and under facts very similar to this one, where the issue at hand was a trust amendment and whether it was valid. And the court said, the essence of the underlying action was not a challenge to the existence of the trust. It was a dispute over who would control and benefit from it. Whether or not the contest prevailed, the trust would remain intact. On one side of the dispute were Margaret and her heirs. On the other side, Whittlesey and her heirs. Whittlesey initiated the litigation to have the amendment voided and to establish her rights as a beneficiary to the trust. The interest of the trustee would have been preserved had the trustee remained neutral as between the parties while they sought in good faith a determination of the question of the validity of the trust provision of the will. Instead, the trustee chose to join in the litigation and to defeat the plaintiff. That is impermissible. That is a breach of the duty of neutrality. And if the trustee chooses to make distributions to the subsequent beneficiaries and we prevail in the litigation, we are entitled to recovery of all of the trust rate, including the amounts that were distributed out to the subsequent beneficiaries. There can be no.
Let me ask you this, I'm sorry. Were we to agree that the order is immediately appealable and there's a substantial right, were we to agree with that, how far should we go? Should we just address simply the pay order and be done with it at that point?
Your Honor, our request would be that the pay order be vacated and remanded for an order that would be consistent with an opinion from this court, which would state clearly that a trustee has a duty of neutrality, a trustee cannot choose sides and pick one beneficiary and pay their fees, and that attorney fees are to be awarded as costs at the end of the matter after an adjudication on the merits. There should be no payment of attorney fees during the pendency of the litigation.
So the rest of the issues that were in the litigation, none of those are before us here.
No, Your Honor.
So basically, I think of the word a standstill agreement. Is your pay order in effect a standstill agreement as to Goldman Sachs?
Yes, essentially it's a standstill order from the other side. In a will caveat, there's normally an order entered immediately freezing distributions from the estate for exactly this reason. Here we have an order that does the exact opposite. It gives them carte blanche authority to pay one set of beneficiaries attorney fees with no liability for having so done.
Thank you. We appreciate all your arguments today. Most interesting. Thank you.
Thank you, Your Honors.
Mr. Sawyer, would you please adjourn court?
This session of the North Carolina Court of Appeals is now adjourned.
Thank you.